Please be seated. The court will now hear argument in Iowa Supreme Court Attorney Discipline Board versus Ruben Andrew Neff. Mr. Sease.
Court. As mentioned, my name is Matthew Sease, and I represent Ruben Neff in this matter. Today, we ask that this court reverse the findings of the Grievance Commission in that Mr. Neff violated Iowa Rule of Professional Conduct 32.8.4 sub G. We ask this for two reasons. First, we ask that this court find that none of the conduct that Mr. Neff engaged in constituted sexual harassment under Rule 32.8.4 sub G. And secondly, alternatively, we ask that this court find that Mr. Neff's protected by the First Amendment as it relates to the conduct that happened in this case.
Watkins to find that this was not sexual harassment within the meaning of the rule?
Outright overrule Watkins. I think that you can modify Watkins, and the biggest problem that I see and the potential conflict with Watkins in the reading of the rule is the expansion of the definition of sexual harassment to include gender harassment. And I think what's happening in Watkins and the interpretation that led to the prosecution of Mr. Neff in this case results in that we're starting to blend sexual harassment with gender discrimination. And if it's gender discrimination, then it would have to fit under the second provision of 32.8.4 sub G, which says that it's other unlawful conduct. And if it's unlawful conduct, his actions or any attorney's actions have to be in violation of some law. So it has to be unlawful. So it has to be in violation of Title VII or the Iowa Civil Rights Act or some other anti-discriminatory actions.
To redefine sexual harassment, I think as we define it in Stansberry, physical or verbal act of a sexual nature that has no legitimate place in a legal setting. Is that still a good definition?
Actual definition, the first definition of sexual harassment came from Steffi's in 1999. And in Steffi's, they quoted Black's Law Dictionary, and I think it's basically the same thing, where it says there's sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. And that's what the definition was in Steffi's, and it's been adopted.
Position, I think. And let me read you from Watkins or from Steffes. It's a verbal act. So here we have words, right? So that it meets that. And it says of a sexual nature. And here he uses the F word. He makes some allegations about rape. The board says that's of a sexual nature. It seems like you're agreeing with that definition. If you are, then why isn't there a violation of the rule?
Well, two reasons. First, Steffi's left out an important part of the Black's Law Dictionary definition. And the next words of the Black's Law definition after other verbal or physical conduct of a sexual nature, the Black says prohibited by federal law and commonly by state statutes. And so Black's is recognizing that definition as it has to be prohibitive under federal law. And that's where Steffi's and Moothart and I believe and even Watkins recognize that, well, we can't say that it has to be in violation of Title VII. And I don't necessarily disagree with that because Title VII is obviously limited to an employee-employer context. And I think it's fine for the court to say we are going to govern behavior of attorneys outside of that as it relates to dealing with clients, court personnel, or people of that like that wouldn't fit technically within Title VII. But where I have the problem, and I think that the issue arises that creates all of these other issues with the First Amendment and that is when we are saying, yeah, Title VII doesn't apply, so that means the requirements of severity and pervasiveness don't apply. That's where we run into all of the constitutional problems. Now, and going back to Steffi's and even in
the employment context at least, that there should be a higher threshold. And maybe it's not jot for jot the same as Title VII, but something that's approaching what would be Title VII liability.
Understand your question correctly, I think that's exactly what I'm saying, is that we aren't going to say that, well, like in the context of dealing with court personnel, if an attorney is referring to that court personnel in a derogatory, sexist manner, and it's pervasive enough that it either affects that person or people around that attorney, then that would be a violation, even though it wouldn't technically be a violation of Title VII. But to go back to your original question, I don't believe that these items are sexual in nature either. And going back to Steffi's, if you look at what the reason they found, this court found a violation in Steffi's is Mr. Steffi's had taken photos that were not related to his representation, arguably. He was arguing that they were related to his representation, but they were of a female client of his in a drug case. He took photos of her back and of her front while she was not clothed. And the court in that said, we find that this is sexual harassment, and it was sexual in nature because it filtered into Steffi's prurient nature. And I think that's what the issue is, that you can still have that sexual in nature.
In Watkins, we also defined it as a put-down aimed at degrading or demeaning women. Is that no longer a good definition?
It is in the context of sexual nature. And if you look at where that language comes from in Watkins, that comes from the Fitzgerald article, which is not a, and is clear within the context of the Fitzgerald article, is not a legal treatise or was being interpreted as the law is supposed to be written. Those were psychologists and professors that said, we are doing this with a feminist viewpoint in interpreting how we believe sexual harassment is, to outline what it is. And it is broader than what the law may require. And then they specifically talked about gender harassment as a subset of sexual harassment.
And we can argue about these particular statements and what they mean. But let's just take an easy one. Let's say Watkins said, Neff said, I don't think women are competent and qualified to be judges. And let's say he said it within the confines of his office. Is that a violation of the rule?
If it's a one-off statement like that, I think it's going to run into First Amendment problems by saying that. And it gets closer, and if you look even at the article in that Fitzgerald article, they talk about if it's pervasive enough to affect individuals working and interfering with their work, then it can. But if it's a one-off statement, like you said, and it's offering his opinion to that, I don't know if it necessarily is, and I would argue that it doesn't.
A statement that is made once, but it's part of a larger context where similar statements are being made, and that's enough, isn't it? I mean, we don't just look at the sort of, well, you use this word one time. If you're sort of using similar words a multitude of times, isn't that enough?
It could, if it all lines into the context of everything, to show that these statements are being made because of the person's gender or a viewpoint that's going to affect an individual that's under a protected class. It doesn't even have to be gender, but under a protective class like a typical Title VII case would be and what it would fall under.
I'm sort of thinking out loud, and I'm just one of six of us, but let me kind of come at it a different way. I mean, what it prohibits is sexual harassment. And I'm maybe less concerned about the First Amendment part of it than maybe some of the other members of the court. But I am concerned that it has to be sexual and it has to be harassment. So that tells me kind of two things. I'm not a Title VII lawyer. I'm not an expert in that. But it says you can first of all, you can sort of say what you want if you go off on a desert island and you say it, because you're not harassing anybody. Secondly, you can say things that are, you can be a pain in the neck but if it's not sexual in nature, then it doesn't meet the definition. So it has to meet both components. Is that too complicated or too simple a view of it?
That you're not practicing, you are on track with what Title VII courts have found, particularly the court or that the board relies on in Reeves. The Reeves case outlines a female employee that was objected to a barrage of insults, including the word bitch, that forms basis here, but it's on and it's being used in a different context, and it's pervasive. And in that case specifically, the court said, we're not going to, and Title VII is not a general civility code. And I don't think that Rule 32 8.4G should be a general civility code either. And so if the claims do not reach to the level, or they're indiscriminate, if it's an indiscriminate discussion about sex, or the use of derogatory terms or vulgar terms, it does not necessarily by itself lead to a finding of sexual harassment under Title VII.
To be sexual in nature, to be sexual harassment, correct?
Well, I think the Title VII reading of sexual harassment is the same reading as the Black's Law Dictionary definition.
Then there can be sexual harassment, hostile work environment, sexual harassment for any treatment that creates a hostile environment because of someone's sex, whether the comments are actually sexual in nature or not.
Level of pervasiveness, yes.
Like, it doesn't have to be sexual to be sexual harassment within the meaning of Title VII. I mean, it's an under-inclusion, over-inclusion problem.
I understand what you're saying, yeah.
If an employer says, we are going to unfairly treat women in our workplace for the purposes of driving them out and making it hostile, but we're not going to use any sexual statements. We're going to criticize their performance evaluations over harshly. We're going to require them to be here at odd hours of the night. We'll never give them any meaningful work. I mean, you get the point. So it doesn't have to be sexual in that sense to constitute harassment.
And here's where I struggle with that, is what you've just described, I believe, is sex discrimination. And it's discrimination based on that person's gender. And treating a specific class of individuals differently because of their gender. And that's different than sexual harassment, which it involves the physical conduct and things like that involve sex acts or the threats of sex acts or just the general discussions of sex acts in a way. And I think if you put it back into Steffi's, further the prurient viewpoint of the person that's uttering those words.
Appears in subsection G.
But it's got to be unlawful discrimination. So the conduct has to rise to the level of a violation of Title VII. And to take it back to this case, I don't think there's anybody that could argue that if this was a Title VII case, that it would survive even a motion for summary judgment, let alone be successful on the merits to determine that it is an unlawful violation. The actions in this case are not pervasive enough to get to and rise to that level.
The First Amendment.
And I see my time's about out, so I'm going to keep it brief. But we rely heavily in the decision by the Idaho Supreme Court, and their striking down of Idaho's proposal of the ABA's version of 8.4. And arguably, the way that Watkins is being interpreted and being used in this case, our standard is actually broader than what happened in Watkins, or what the proposed language was in Idaho that was ultimately struck down. And I think it's important to point out what the language was in that case, or what the rule was proposed. It says that harassment must be severe or pervasive enough to create an environment that is intimidating or hostile to a reasonable person. That was struck down as being in violation of the First Amendment. And that's arguably a more strict reading than what we have in this case. And in fact, I'm not certain in reading the rules that were proposed in Idaho that Mr. Neff would have even been charged if that was the standard. Because in the comments, they specifically say that you look to the frequency of the harassing conduct, its severity, whether it's threatening or humiliating, or a mere offensive utterance, whether it's harmful to another person or whether it unreasonably interferes with conduct related to that. Petty slights, annoyances, and isolated incidences, unless extremely serious, will not rise to the level of harassment under that section. Now, the Idaho Supreme Court said that that was both overly broad in its terms, and it was unconstitutionally vague. And I think if that was the situation there, we certainly reach that level in this case. I see I'm out of time. Thank you.
May it please the court, opposing counsel. My name is Rob Howard, and I represent the Appellee, the Att'y Disciplinary Board. The board is asking that this court uphold the constitutionality of Iowa Rule of Professional Conduct 32.8.4G and find that Mr. Neff violated that on several occasions. The rule is constitutional as it survives strict scrutiny, is not overly broad, is not vague, is constitutional as applied to Mr. Neff, and Mr. Neff violated this because he is a lawyer who engaged in sexual harassment or other unlawful discrimination in the practice of law without a legitimate legal purpose.
Let me ask you this. Let's assume two female attorneys in this office were in the lunchroom talking about a sexual encounter one of them had over the weekend. Does that violate the rule?
In that context, I mean, I do believe that it would have to, yes, I believe it would violate the rule. The idea of women and women or same-sex violations has been dealt with by the U.S. Supreme Court in Onkale v. Sundowner Offshore Services.
Is that there was a verbal act, it involved sex, it wasn't relevant to the work topic or the workplace.
You're correct.
You think the board thinks that's harassment?
It would be, if they're in on the lunch break, is that the practice of law? That would be a fact question that we'd have to get into. Being in the practice of law.
Desks and their cubicle co-workers, and they're talking about a sexual encounter over the weekend. Is that sexual harassment in the board's view?
Their coworkers or with their coworkers.
They're in this county attorney's office. They're both women, and they're talking about sex unrelated to any case in the workplace.
I do believe that that would be under the Watkins definition, sexual harassment, and under Moothart, where this court has said it's a per se rule regarding sexual harassment, even if it wouldn't give rise to civil liability. It's verbal acts.
Asked in that context.
I think that is a procedural thing that may happen. Let's say that in that example, one of the females was like, I didn't want to hear that. That would be the only way that the board would actually ever hear about it. So if it occurs in a vacuum, just like some other items might occur which never are heard from, I do believe that somebody does have to feel harassed in it, but that's more of a procedure on how it would actually be move up the line, rather than if it is a violation.
Doesn't matter. Justice McDonald's question is about whether or not that's a violation. Is it a violation? A violation happens whether somebody reports it or not, correct?
But I believe that that kind of goes to is it something where somebody would have to feel harassed then? There would have to have that. And I do think that there's sort of this subjective objective that would happen. So what would happen procedure-wise is...
Office of all men, and they just engage in horrible behavior, and they think it's hysterical and funny, and nobody feels harassed. Are you saying that that's okay?
No, I think that would be clearly a violation of it. I guess, big picture...
I mean, that's the problem. Who's the harassee then?
This kind of brings us to the strict scrutiny analysis, which is what the compelling interest is here. And that is the equal and unhindered participation with the practice of law. So let's say, obviously, you know, these things happening in a hermetically sealed environment where nobody ever hears about them, then nothing ever happens. I mean, that's just a fact. However, why this rule was created was because people were hearing about it. They were hearing that that's how lawyers behaved. It was driving women out of the practice of law or engaging with the practice of law, not only from the workforce, but from engaging with the court system.
In this case?
That was one of the stipulated facts that 2 women left their employment in part because of Mr. Neff's conduct.
I mean, the notion of, like, let's say you had 2 male attorneys who you know, like one of the allegations in this case, or actually it's not an allegation, it's a stipulated fact, you know, several times use the B word to refer to a female judge, all right? So let's say that happens. It's 2 male attorneys, you know, kind of, and I understand that language is offensive, and it can, there's an undertone that you're respecting that judge less because of the judge's gender. But if they both, you know, if neither one is harassing each other, how is that sexual harassment?
The fact that if especially from a county attorney, that his opinion of female judges, and again, I would say that the way that was charged and brought was as a whole. He said things about a male judge, he said things about...
Hypothetical, you're not going to change it.
Yes, again, I would go back to the fact that it's how this gets out, and then we have a county attorney, and we understand that the perspective is that female judges don't make good decisions. I do think that we're not looking at who's necessarily harassed, it's sort of the legal community in general, and that's the protection, that's the compelling state interest.
That sounds like the part of the rule that this court didn't adopt, you know, the sort of expressions of bias and things like that. That sounds like an expression of bias to me, but harassment, you know, in Watkins, there were 2 people that clearly were being harassed. Here, there are 2 people that are allegedly were harassed as well, and that needs to be addressed. But it seems to me you have to have a harassee in order to fall under that part of the rule, right?
I think that it is something more where it's about how it affects the legal community in general. I think that even if there was in your example where it's a bunch of guys sitting around the law office while practicing and they're making a bunch of jokes and that gets out, that is the compelling state interest, is that people are like, ick, I don't want to deal with the legal community. And we have to make sure that we are having equal access to it. So I think that I understand that you're saying that there must be somebody who actually feels harassed. We actually do have that in this factual stipulation.
Let me phrase it this way. Let me turn your attention to the text of the rule and the words "or other." What work is that doing? Specifically, the word "other."
I suppose sexual harassment or other unlawful discrimination. I think that is partly why the court did not adopt such a strict reading of sexual harassment or other. But
At least that implies to me that sexual harassment, as used in that sentence, must also be unlawful, right? Because it doesn't say sexual harassment or unlawful discrimination. It says sexual harassment or other unlawful discrimination.
would be that it would be sexual harassment or rather than and other unlawful discrimination. So I think you'd have sexual harassment or you'd have other unlawful discrimination. I do believe that
What work does the word other do in that sentence? You could say sexual harassment or unlawful discrimination.
is what it does. It does make it a very broad, just like sexual harassment was defined broadly, other unlawful discrimination is defined broadly. So I would disagree with Mr. Neff's position.
It's unlawful discrimination or it's not. What does other unlawful discrimination mean?
I my plain reading of the text would be any other unlawful discrimination. Maybe I'm not understanding the question correctly, but I think that "or" very clearly separates two different items.
The natural way to read that is sexual harassment. And when you say "or other unlawful discrimination," the implication is sexual harassment must also be read to be a form of unlawful discrimination, which means there has to be some sort of, approach to a Title VII threshold to get there.
Well, I do think that Mr. Neff's position is correct, where there is an approach to Title VII analysis there, and they did take our definition of verbal conduct of a sexual nature from Title VII. That's where it gets from Black's Law Dictionary. I think this court intentionally ended it there. I think the other unlawful is making it very broad for any other type of discrimination that may occur that obviously is unlawful as well.
Ambiguous. Shouldn't we construe the rule in a way that avoids a First Amendment problem? That is, by requiring the sexual harassment to be literally unlawful under Title VII or the Iowa Civil Rights Act or some other law.
I would disagree with that. So the compelling state interest here is very much different. It is making sure that everybody has equal and unhindered access to the practice of law. So because we're not talking about just an employment context, and this comes out in mistaken. And I think the homosexual slur, that's pretty severe. I think the comments about the criminal defendants wishing sodomy and bestiality and painting a fairly pornographic picture for his employees, that's pretty severe.
Sexual? He says he wants this guy to be mauled by lions and rape. I don't see how that's sexual. I mean, it seems silly, stupid. It seems like that's a really overly literal reading of this to say that, I don't know. The factual matter, I have a very difficult time finding that to be sexual.
Problem that he wished the criminal defendants would be mauled by lions, at least under this. It's that they were sodomized. That's the board's issue, is that he wished sodomy upon them in very graphic detail.
Legislature agreed that this is a really important issue about making the profession free of sexual harassment. And they passed a statute that codified our rule and criminalized it. If Mr. Neff had said, for example, this judge is a limp dick, would it violate the First Amendment to send him to jail for saying that?
Actually, the way that this was brought, I would say no. Just a one-off comment in that instance may not violate this. It's what we were able to glean, and this was the way that the board brought it, from limp dick and bitches. We were able to glean what his perspective was on sort of gender stereotyping. So I think there was a pervasive element here that existed, though not necessary under this court, as this court has previously defined, but I think there was a pervasive element. And that's something that we have, is we have severity on one hand with a couple of his comments, we have pervasiveness with his other comments, and there were multiple comments here. I think that this ultimately
Necessary. So you think that he could, for example, commit a criminal offense by calling judges bitches, and that would be square with the First Amendment?
I believe that it would be the same, it would be square with the First Amendment as any harassment is. But the reason why it's square with the First Amendment in this case and in other harassment cases is that legitimate legal.
I ask you one sentence, and you keep saying that would be okay if it was pervasive. And I think that's right? I mean, that's why we have Title VII, and there's this threshold of pervasiveness that actually alters somebody's condition of employment. I'm asking you to survive constitutional scrutiny, is that pervasiveness requirement necessary? And if not, can he go to jail for saying a judge is a limp dick? One time.
I'm sorry. Yes, it would be as any other harassment, State v. Frodsky, State v. Baker, any other harassment. I'm assuming if it was criminal, that's what it would be. However, like those criminal statutes against harassment, this would have the constitutional safety valve. of saying, did he have a legitimate legal purpose for doing it? And if he did have a legitimate legal purpose, we can't do anything to you. So that's why it would survive that's why it would survive constitutional muster, is that we crafted this rule just as we craft any harassment or that does step onto First Amendment grounds. And it is
Years ago expressly declined to adopt the additional language in the ABA model rule. Is the board trying to get us to work that back in by court interpretation here?
the additional discussions with the ABA rule, there was a couple of issues, and ours is definitely more on that spectrum of constitutionality, more safe. And the reason is that it does have that constitutional safety valve, which the ABA rule did not. That's why Pennsylvania said that's a little bit too much, but in Colorado, they said it's just fine. I see that I'm out of time.
May it please the court. I think, Justice McDonald, I want to go back to one of your questions, where if it's just females in the office and they're making statements, we actually kind of have that in this case. And I think that outlines what the problem is that the females in this office, and this was a female-dominated office, as we stipulated to, 9 of the 10 employees were all were females in this. So it was only Mr. Neff and another male were the only males in this office. And the females in this office were engaged in "that's what she said" jokes based on the Office television show. And then Mr. Neff joins in with it once after it had been consistently through the office, and now he's getting rung up. And in that world, I'm not saying that "that's what she said" can never be lead to the level of sexual harassment. I think anybody, that's what made The Office a fun show, was that anybody could look at that and say Michael Scott was in violation of Title VII when he was saying that throughout. But when he says it, Mr. Neff says it once in this context, he is not violating.
About blowing snow and his wife not objecting to it or liking it or something. So we know what the context is, that he said it. Do we know the context of when it was used by the other people in the office?
It's fair to assume that it would have to have that same sexual innuendo that's found. I mean, if we're assuming that it's along the lines of what was happening in the office, I think that's the purpose of that, and that's the natural extension of that. But as far as specifics, we don't have any of that. That's part of the stipulation in any event.
Can you respond to the board's argument that it's unfair, I think is what they're saying, to look at each of these specific statements in isolation, and if you combine them together, you would reach at least a sufficient level of pervasiveness that might avoid any constitutional problem?
I don't agree that if you do that. I think you do have to combine that. I think that that's fair, that you have to look at the totality of the circumstances. And it goes back to our prior discussion. It's got to reach to the level of pervasiveness. And the only reason you can make that determination is by looking at the totality of the circumstances to determine whether it's pervasive or not. But I think it's important to look at them first individually and then check that box that it's not any one of these comments individually do not satisfy that burden. And then we look at it collectively. And I still don't believe that in this context, in this case, in the stipulations that happen here, it reaches that level.
Let me ask about the gay slur incident. So as I understand, am I reading the stipulation correctly that your client used it in the context of relating a story, that something secondhand? One of the individuals said she was offended, then your client used it again in the context of asserting his right to tell the story. Is that?
Really right. I think I know the situation, so I hope I'm not adding information that's not in the stipulation, because we're obviously bound by that. But the context of it was a person from the public called into the office and said that the prior county attorney was that gay slur. And Mr. Neff, relayed that story to one of the staff members. The staff member says, "Hey, you can't say that." And then his response is something to the lines of you're telling me I can't say that, or why can't I, or can I have the right to say that that county attorney is that gay slur. That one time, and then that's it. There's no other instances of any sort of sexual orientation discrimination that happened throughout this stipulation.
Find a violation, are we too late for a private admonition since this is being live streamed and is on our public record?
Attorney-client privilege discussions I had with my client, the reality is that this was very public as part of the employment discrimination hearing, and so we could have certainly requested the court make this confidential and use a domain, but we decided not to add that extra effort in this case due to the prior publicity outside of this. But I still think a private admonition would be appropriate if that were the case. Thank you.
Concludes our morning session. You may adjourn court.